Okay, I'm reading Chapter 13, Introduction, the Duty to Disclose. In order to make the criminal trial less a game of blindsman bluff and more a fair contest with the basic issues and facts disclosed to the fullest practical extent, from U.S. v. Procter & Gamble Co., 1958. The state and federal criminal justice systems over the last few decades have expanded dramatically the obligations of both prosecution and defense to disclose to the other side before trial the evidence that each intends to use at trial. This movement toward liberal pretrial discovery initially emphasized prosecution disclosure to the defense. The permissible scope of defense discovery varied, but one constant objection to expanding such discovery was the absence of reciprocity and disclosure obligations, the failure to make discovery a two-way street. This, in turn, led to expansion of the defense obligation to disclose its evidence to the prosecution. Most jurisdictions, however, concerned about possible constitutional objections to imposing such an obligation on the defense, initially provided the prosecution with very limited discovery. One of the earliest measures providing for prosecution discovery was the reciprocal alibi notice statute. The first case in the chapter, Williams v. Florida, treats the constitutionality of such a statute. The ruling in Williams is seen by many as giving the states leeway constitutionally to grant the prosecution a fairly expansive right of discovery. It led to a variety of broadened reciprocal discovery requirements. For example, requiring defense disclosure of the names of all of its intended witnesses, none of which have subsequently reached the court. While pretrial discovery requirements are designed primarily to avoid surprise and thereby allow a party ample time to build a case responsive to its opponent, the due process doctrine explored in United States v. Bagley actually requires the prosecution to assist the defense in building its case. In Brady v. Maryland, 1963, the Supreme Court established a constitutional duty of the prosecution to disclose to the defense exculpatory evidence that is material to the issues of either guilt or punishment. Bagley explores the scope of this Brady rule. Pennsylvania v. Ritchie raises the question of whether the prosecution's obligation to assist the defense in preparing its case goes beyond the Brady rule as a result of the defendant's Sixth Amendment rights to confront opposing witnesses and to present witnesses in his favor. Other aspects of those rights are considered in Chapter 18. Williams v. Florida, 1970. Justice White delivered the opinion of this court. Prior to his trial for robbery in the state of Florida, petitioner filed a motion for a protective order seeking to be excused from the requirements of Rule 1.200, now Rule 3.200 of the Florida Rules of Criminal Procedure. That rule requires a defendant on written demand of the prosecuting attorney to give notice in advance of trial if the defendant intends to claim an alibi and to furnish the prosecuting attorney with information as to the place he claims to have been and with the names and addresses of the alibi witnesses he intends to use. In this motion, petitioner openly clarified his intent to claim an alibi but objected to the further disclosure requirements on the ground that rule compels the defendant in a criminal case to be witness against himself in violation of his Fifth and 14th Amendment rights. The motion was denied. Those are the facts. Procedurally, the motion was denied. Florida's notice of alibi rule is, in essence, a requirement that a defendant submit to a limited form of pretrial discovery by the state whenever he intends to rely at trial on the defense of alibi. In exchange for the defendant's disclosure of the witnesses, he proposes to use to establish that defense to call this that the issue over compulsion. All right. So in exchange for the defendant's disclosure of the witnesses he proposed to use to establish that defense, the state in turn is required to notify the defendant of any witnesses it proposes to offer in rebuttal to that defense. Both sides are under a continuing duty to promptly to disclose the names and addresses of additional witnesses bearing on the alibi as they become available. The threat and sanction for failure to comply in this exclusion of trial of the defendant's alibi evidence, except for his own testimony, or in the case of the state, the exclusion of the state's evidence offered in rebuttal to the alibi. In this case, following the denial of its motion for protective order, petitioner complied with the alibi rule and gave the state the name and address of one Mary Scotty. Mrs. Scotty was summoned in the office of the state attorney on the morning of the trial, where she gave pretrial testimony. At the trial itself, Mrs. Scotty, petitioner, and petitioner's wife all testified that the three of them had been in Mrs. Scotty's apartment during the time of the robbery. On 2 occasions during cross-examination, Mrs. Scotty confronted her with her earlier deposition, in which she had given dates and times which in some respects did not correspond with the dates and times given at trial. Mrs. Scotty adhered to her trial story, insisting that she had been mistaken in her earlier testimony. Excuse me. The state also offered in rebuttal the testimony of one of the officers investigating the robbery, who claimed that Mrs. Scotty had asked him for directions on the afternoon in question during the time when she claimed to have been in her apartment with petitioner and his wife. We need not linger over the suggestion that discovery permitted the state against petitioner, in this case deprived him of due process or a fair trial. Florida law provides for liberal discovery by the defendant against the state, and the notice of alibi rule is itself carefully hedged with reciprocal duties requiring state disclosure to the defendant. Given the ease with which an alibi can be fabricated, the state's interest in protecting itself against the 11th hour defense is both obvious and legitimate. Reflecting this interest, notice of alibi provisions dating at least from 1927 are now in existence in this substantial number of states. The adversary system of trial is hardly an end to itself. It is not yet a poker game in which players enjoy an absolute right always to conceal their cards until played. We find ample room in that system, at least as far as due process is concerned, for the instant Florida rule, which is designed to enhance the search for the truth in so that's the legitimate state interest, right? Search for the truth in the criminal trial by ensuring both the defendant and the state ample opportunity to investigate certain facts crucial to the determination of guilt or innocence. Petitioner's further contention is that he was compelled to be a witness against himself, contrary to the commands of the 5th and 14th Amendments, because the notice of alibi rule required him to give the state the name and address of Mrs. Scotty in advance of trial, and thus to furnish the state with information useful in convicting him. No pretrial statement of petitioner was introduced at trial, but armed with Mrs. Scotty's name and address and the knowledge that she was to be petitioner's alibi witness, the state was able to take her deposition in advance of trial and to find rebuttal testimony, also requiring him to reveal the elements of the defense is claimed to have interfered with his right to wait until after the state had presented its case to describe how to defend against it. We conclude, however, as has apparently every other court when has considered the issue, the privilege against self-incrimination is not provided by a requirement that the defendant give notice of an alibi defense and disclose his alibi witnesses. The defendants, wait, you're concluding that the privilege against self-incrimination is not violated by that. statute. So the defendant in criminal trial is frequently forced to testify himself and to call witnesses in an effort to reduce the risk of conviction. When he presents his witnesses, he must reveal their identity and submit them to cross-examination, which in itself may prove incriminating or which may furnish the state with leads to incriminating rebuttal evidence. That the defendant faces a dilemma demanding a choice between complete silence and presenting a defense has never been thought an invasion of privilege against compelled self-incrimination. Pressures generated by the state's evidence may be severe, but they do not vitiate the defendant's choice to present an alibi defense and witnesses to prove it, even though the attempted defense ends in catastrophe for the defendant. However, so Lizzie Mordius versus Oregon may have had a different result. Actually, no, it says it failed to provide reciprocal defense discovery, violated due process, so it's consistent. Where was I? Catastrophe. However, testimonial and incriminating the alibi defense proves to be it cannot be considered compelled within the meaning of the 5th and 14th Amendments. Very similar constraints operate on the defendant when the state requires pretrial notice of alibi and naming of alibi witnesses. Nothing in such a rule requires a defendant to rely on an alibi or prevents him from abandoning the defense. These matters are left to his unfettered choice. That choice must be made, but the pressures which bear on his pretrial decision are of the same nature as those which would induce him to call alibi witnesses at the trial. The force of historical fact beyond both his and the state's control and the strength of the state's case built on these facts. Response to that kind of pressure by offering evidence or testimony is not compelled self-incrimination, transgressing the 15th and 14th Amendment. In the case before us, the notice of alibi rule, so there's no inducement or compulsion. So let's apply it to these facts. No way affected the petitioner's crucial decision to call alibi witnesses or add to the legitimate pressures leading to that course of action. At most, the rule only compelled petitioner to accelerate the timing of his disclosure, forcing him to divulge an earlier date information which the petitioner from the beginning planned to divulge at trial. Nothing in the Fifth Amendment privilege entitles the defendant as a matter of constitutional right to await the end of the state's case before announcing the nature of his defense, any more than it entitles him to await the jury's verdict on the state's case in chief before deciding whether or not to take the stand himself. Petitioner concedes that absent the notice of alibi rule, the Constitution would raise no bar to the courts granting the state a continuance at trial on the grounds of surprise as soon as the alibi witness is called. Nor would there be self-incrimination problems if, during the continuance, the state was permitted to do precisely what it did here prior to trial, to dispose a witness and find rebuttal evidence. But if so, utilizing a continuance is permissible under the 5th and 14th, then surely the same result may be accomplished through pretrial discovery as it was here, avoiding the necessity of disrupted trial. We decline to hold that privilege against compulsory self-incrimination guarantees the defendant the right to surprise the state with an alibi defense. You see, Berger concurs, Black and Douglas dissent, and it's going to be another 3 pages to get through the dissenting opinion. It's a concurrence, and so I'm going to end here.